Hi, my name is Lior Katz and I'm a bankruptcy attorney here in Los Angeles, California. And today I'm here to talk about creditors. So in bankruptcy, we normally have the debtor or the debtors who file a bankruptcy, but we also have the creditors. And the creditors are individuals or businesses who are owed money by the debtor. Once the debtor files a bankruptcy, there's something called the automatic stay that comes about automatically, and the creditor must stop all collection efforts against the debtor. So in other words, if they started a foreclosure, they have to stop the foreclosure. If they started a repossession of the vehicle of the debtor, they have to stop that repossession. All efforts to collect against the debtor must stop. Now that also includes lawsuits. So if you are a creditor in a bankruptcy and you want to know what to do once a bankruptcy is filed, you probably need to consult with an attorney. Since there's different chapters of bankruptcy, there's a chapter 7, there's a chapter 13, there's a chapter 11. Since there are different chapters in bankruptcy, there's different work that has to be done by a creditor in each of those chapters. For example, if a debtor files a chapter 7 bankruptcy, and if you are a landlord, for example, and you want to continue with an eviction you had started, or if you want to start an eviction, you have to file what's called a motion for relief from the automatic stay. Same goes with a lender who lends someone money, proceeded with foreclosure. If the debtor files a bankruptcy, again, you have to file a motion for relief from the automatic stay. That's usually done in chapter 7 bankruptcies, but it's also done in chapter 13s and chapter 11s. Now going on to another item that the creditor must do in a bankruptcy is, for example, in a chapter 13 or a chapter 11, a creditor must file what's called a proof of claim. That's a form that gets filed with the bankruptcy court, and he notifies the court and everyone else, including the debtor, how much the creditor is owed. If you don't file that proof of claim, there could be some major repercussions against you and you can lose the entire claim. So you must do so in time. Again, there's other matters in bankruptcy that require the help of an attorney when one is a creditor in a bankruptcy, but you always want to make sure that you're protected and that you hire someone who knows what they're doing. They have to review the docket of the case to see what was filed in the bankruptcy, determine if the debtor is hiding anything or is misstating anything that can help your case. And in other words, you have to do whatever you can in order to fight the bankruptcy so that, number one, you don't lose your claim, or number two, that your claim is not modified, reduced, or anything of that sort, where again you can lose some major money if you're a creditor and holding a claim against the debtor. So if you want to learn a little bit more, and if you're a creditor in a bankruptcy, if someone owes you money, they didn't pay you, and now they filed a bankruptcy, or if you're a plaintiff in a lawsuit and in the middle of a lawsuit, bankruptcy was filed by the defendant, you need to consult with an attorney and we'll be happy to help you out. Again, my name is Lior Katz and I'm a bankruptcy attorney, and my firm helps individuals and businesses who are creditors in bankruptcy. And if you want to learn some more, give us a call at 310-444-9444 or visit us on the page at www.creditorslawyer.com. Thank you, and please click the subscribe now button. Have a good one.